in turn, is based on a rule that we'll look at today. It's called Federal Rule of Civil Procedure 26. The standard for Federal Rule of Civil Procedure 26 is a very broad standard, which we'll look at today also in detail. But suffice it to say that the standard in Federal Rule of Civil Procedure 26 is such that a party can obtain from an opposing party or even a non-party evidence that itself is inadmissible, but that can lead, reasonably can lead to other discoverable evidence. So that's very broad. That's very, very expansive. Now there has been reform to that expansive rule, which makes it much better, I think, and internationalizes it, because it brings in factors such as proportionality, the amount in controversy, the extent to which evidence gathering can be burdensome on a party. These factors are brought to bear as limiting tempering factors, but still subject to those qualifications. Evidence gathering is very, very broad, very different from international arbitration. In international arbitration, as we will discuss, evidence gathering under the IBA rules, now the December 17, 2020 IBA rules, is subject to a standard which was first incorporated in the 2010 rules. And that standard is relevant to the case and material to the outcome. That's a very narrow standard when compared to the Rule 26 standard. It's also very narrow and incomplete, even though we welcome it and we're glad that it exists, but it's incomplete because in the IBA rules, the word evidence really is not defined, and the word relevance is not defined, and the word material is not defined, and it has a good faith component to evidence gathering, but good faith, of course, is not defined. And in many ways, perhaps it cannot be defined, because to define it may be to tie it to a particular legal culture. But I can tell you that even within the United States, in different areas of law, the word good faith itself has different meanings. Now, in the United States, of course, discovery, which is not evidence gathering, it's discovery, also is subject to a rule called Rule 30, denominated as Rule 30, which means that you can take oral testimony from a witness. And that means that you can examine the witness. Now, that witness will be under penalty of perjury. Perjury is a crime. Perjury is lying under oath. And you can ask that witness questions. So tell us, when did you first read the contract? And at the time that you read the contract, you understood that payment was necessary. And you knew that payment had to be made by a certain amount at a certain date. Meanwhile, the witness is answering the questions, you see? And the witness, that deposition is transcribed, literally, and or transcribed and also videotaped. But there's also an evidence gathering of documents under Rule 34 that allows you to propound what's called a request for production of documents. Again, all under the Rule 26 standard. So under Rule 30, the depositions, you're asking questions, it's under the Rule 26 standard. You're asking for documents under Rule 34, it's also under the Rule 26 standard, a very broad standard. You also have requests for admissions under Rule 36, and you also have written interrogatories. I just say this very superficially to address Professor Ekshi's concern or question that I explain it. And this is driven, all this is driven by the parties. And the court only walks in when the parties can't agree on entitlement to information or a document, or even the inspection of a place. So that's the American, the US common law discovery, very, very different, pulls apart from evidence gathering. But if you look at the IBA rules as we're going to look at them, the real issue becomes whether the American influence on those rules, if you do find an influence to those rules, whether you think that really is an internationalization versus an American influence, or whether you believe that it really has a positive effect, because as I believe, I think that it's conducive to transparency. I think it's conducive to risk assessment. I think it's conducive to truth. You know what's out there for both sides. There are no surprises at the time of the hearing. And I also think that, and believe very firmly, that you get this information at a time, if you do it correctly, when settlement is possible, when the economics will lead to a resolution of the dispute, rather than waiting 3 years to have a full evidentiary merits hearing. This is what I propose that you think about as we go through this. The text, the book, does argue that not all of the doctrinal developments in international arbitration that may be traced to or associated with American doctrinal developments are negative. Indeed, it asserts that many American precepts in fact address these concerns and actually meaningfully help international commercial arbitration's ability to redeem the promise that we said that it seeks to address, namely to be expedient, to be efficient, to be transparent, and to have predictive value. So in the text, we aspire to a comprehensive understanding of the arbitral process as an attempt to find equipoise between party autonomy as a conceptual and practical check on arbitrator discretion. The text also raises the question of whether we should be expected, whether we should expect, from the rules of sponsoring institutes, more elaborate rules. The problem with this is, if you have more elaborate rules, then it's very difficult to hold yourself out as just being completely neutral and international in that sense. The more rules you have that actually start defining things like evidence, admissibility, burden of proof, what is the burden of proof, materiality, good faith, then it becomes substantive to some extent, less universally procedural. The second problem is that if you expect from the institutional rules, ICC, ICDR, from those institutions, more substantive rules or more guidance on evidence gathering, then evidence gathering in arbitration loses the very flexibility that it purports to have. So any such revisionist movement aimed at providing greater guidance as to manner, content, and scope would threaten carving out of the arbitral process the very flexibility that provides arbitration with global appeal. And you have to also ask yourselves whether such revisions rekindle the irreconcilable conflict between common law and civil law tensions, rather than, again, expressing that conflict through a different vocabulary altogether in the form of party autonomy and arbitrator discretion. Would efforts to establish equipoise between party autonomy and arbitrator discretion be perceived as an intellectually dishonest attempt to diminish the standing and contribution of the civil law cultural tradition concerning evidence gathering? I ask you, is it possible to view the IBA rules on the taking of evidence in international arbitration, a resolution of the IBA Council of December 17, 2020, with its many references to orality, oral advocacy, as an effort to establish equipoise between arbitrator discretion and party autonomy? I ask you. At a time when many civil law jurisdictions are incorporating orality, oral advocacy, into their respective codes of civil procedure, is it intellectually rigorous to assert that the IBA rules are unduly Americanized? Would it not seem to be more prudent and therefore reflecting greater precision to suggest that traces of US common law are present in the IBA rules, but only as part of an amalgamation of many juridic cultures, and that these rules are far more than just a petri dish of competing civil law and common law traditions. The book I wrote, The American Influence, does not aspire to answer these questions. Such would be a very presumptuous and too ambitious an undertaking. But it does address these concerns by approaching the US law of international commercial arbitration with inquisitive humility rather than with the prejudice founded on half-truths, platitudes, or a less than comprehensive understanding of relevant US procedural norms. Of course, any analyses of these issues also would need to consider the rules on the efficient conduct of proceedings in international arbitration. You know these as the so-called Prague Rules, both substantively as well as a legal cultural statement of social, juridical, anthropological phenomenon that is a reaction to select features of the IBA rules as conducive to economic inefficiencies and lack of expediency. Even assuming the IBA rules indeed are responsible for these shortcomings, would it be accurate to assert that such debilities can be cured by transferring the most theoretical party-driven initiatives provided for in the IBA rules simply to the arbitral tribunal? In other words, the Prague Rules basically say the IBA rules are Americanized versions of purported international rules. They don't work. And the reason they don't work is because there's too much party autonomy in the IBA rules. So here's the solution. Let's just transfer all that party autonomy and centralize it to the arbitral tribunal. Well, you know, what does that get you? What does that really resolve for you? Functionally, you have basically the very similar rules. I know this is controversial, but you have very similar rules, and you're just moving the structure of what is who takes the initiative, the party or the arbitral tribunal. Then you're taking the same body of law, the same body of rules, if you will, to be more precise, and then you're extracting, taking away, removing from the IBA rules all oral advocacy. That is a big difference. You're removing all oral advocacy, A, and B, you are taking party autonomy and shifting it conceptually to the tribunal. Put simply, if the average complex international arbitration, both commercial and treaty-based, lasts slightly over 3 years, would it be accurate to assert, as the Prague Rules unquestionably provide, that such lack of expediency is a consequence of the extent to which the IBA rules favor common law traditions? I say no. Lastly, is the legal fiction that arbitrator discretion in all matters, but particularly with respect to the taking of evidence, is normatively justified because the parties, having participated in the constitution of the arbitral tribunal and agreed to the arbitration clause, are, from a semiotics perspective, somehow participating in the arbitral tribunal's exercise of arbitrator discretion? That's a very long paragraph. Let me tell you what I mean by that. It's very simple. The argument that you hear in justifying a greater weight to the arbitrators, weight that is more significant than the weight accorded to party autonomy, is the following. Arbitrators can have as wide a latitude as possible as decision makers, because those decisions that the arbitrators are making are really the decisions that the parties are making, because the parties selected the arbitrators. So the arbitrator is an extension of the parties in this regard. Well, that may sound to some people as fine, but it really isn't. The arbiter, just because the parties pick the arbitrator, doesn't mean that somehow the parties are being represented in any way by the arbitrators. It does mean, of course, that the parties bear some responsibility for having that tribunal, and therefore that tribunal's exercise of judgment. But that's separate and apart from somehow there being any type of representative direct capacity. I find the argument to be not persuasive and not at all compelling, quite frankly. Let me talk to you a little bit about the IBA rules And let me just tell you that the IBA rules, I believe, represent more than just a conceptual and doctrinal step in the right direction. And that's what we argue in the book. Even though the conceptual structure of the rules does not purport to harmonize competing party autonomy and arbitrator principles, arbitrator discretion, they do de facto provide a very helpful framework on which to understand arbitration the way we're trying to here in this talk. Because the IBA rules represent a very legitimate and compelling effort to integrate multiple legal traditions, the consequence of this drafting effort has the real but unintended effect of tending towards harmonizing party autonomy and arbitrator discretion. On December 17th, 2020, the IBA published the 4th edition of its rules. The most fruitful, however, edition, making the greatest number of structural and conceptual contributions changes, concerned the publication of May 29, 2010, 3rd edition of the rules. That iteration brought about new principles and entire sections that were not present in its predecessor. The IBA rules on the taking of evidence in international commercial arbitration that were dated June 1, 1999. Therefore, for present purposes, unless otherwise stated, I want to trace the doctrinal development as presented in the 2nd edition of the American Influence, which refers to the 2010 iteration of the IBA rules. Our book argues that in large measure, the rules are successful as an embryonic point of departure. The rules adhere to the basic structure of having a preamble, a definitional section, and 9 articles. And the 2020 iteration also has that same structure. At both ends, at the preamble and at the end in Article 9, you find the key terms good faith. And the arbitral tribunal is empowered to sanction a party with fees if it does not conduct the taking of evidence in good faith. And this is extremely, extremely important. And this is why early on I said, but note that the IBA rules do not define good faith, and that international arbitration, what we consider to be good faith in one country may not be good faith in another country and in another tradition. I will tell you this, many times when I'm trying to explain the self-disclosure requirements of international arbitration under the IBA rules to non-common law parties whom I represent, they say things like, well, why would I give them documents that will hurt my position? I don't have to do that in my country, in France or in Germany or in Turkey, or why in China? Why would I have, how can you, my lawyer, ask me to give them documents that will hurt me? I mean, who are you working for anyway? You understand, it's not easy. Even for sophisticated people who have the benefit of general counsel, who have been through many arbitrations, they still say things like, well, what if I can't find it? What do you mean? What are you talking about? No, you have to find it. Oh, it's in, this is a Fortune 500 company as well. It's in our office in India. Come on. Space and time and geography doesn't exist anymore. Come on, get it in India, please, and bring it here to New York. Bring it here. Okay. So that's the structure, preamble, 9 articles. The 2010 version, as previously referenced, significantly builds on the 1999 predecessor with new provisions that reflect very meaningful and mostly positive changes. The new features, so the American Influence, my book argues, contribute to enhancing party autonomy and therefore fostering a tendency towards equipoise between the 2 party autonomy and arbitrator discretion. While to some extent these contributions may be construed as raising the question of the extent to which the rules have been Americanized rather than internalized, a more productive and technically sound understanding would be to pose any such queries in terms of party autonomy and party discretion. In identifying pivotal sources inviting party autonomy Emphasis in these rules is placed on basic issues such as consultation and self-disclosure requirements, or the 2010 amendments introduction of good faith, which the 2020 iteration also keeps. It is necessary to ask whether these contributions at all alter the fundamental relationship between the pillars of arbitration that we now have identified, but most notably party autonomy, transparency, and predictability, and their interaction with the arbitral tribunal's vast inherent powers. The American influence argues that while to some extent these contributions raise the question of the extent to which the rules have been Americanized rather than internationalized, a more productive and technically sound understanding would be to pose any such queries in terms of, again, party autonomy and arbitrator discretion. Indeed, US common law, in contrast to the civil law tradition, that's the type of vocabulary that we need, not this contrast. And identifying pivotal sources, we also look at how good faith and self-disclosure can be best harmonized. When do we know that a party is acting in good faith in a self-disclosure requirement? You must self-disclose, because if you don't self-disclose, then you may be precluded from relying on those documents or certain arguments. Of course, if you're found to be acting in bad faith and those documents are made known through other sources, non-parties, third parties, public records, for example, that also is going to be extremely problematic. The American influence questions whether the rules contain discernible principles that may cause their finest workings where parties and arbitrators alike are steeped in disparate cultures or legal traditions. Are such terms as best efforts and genuine belief susceptible to uniform construction throughout different countries? The American influence invites the readership to question what it can possibly mean to conduct arbitration in good faith. First, focus is placed on self-disclosure and consultation requirements set forth in Article 2 of the rules. Both self-disclosure and consultation also are contained in the 2020 iteration. Article 2 is analyzed with specific emphasis on the expected rule of party autonomy that this provision contemplates. Second, the new iteration provides a standard that pervades the rules and is identified in connection with party autonomy and the relation to self-disclosure and transparency requirements that this fourth generation embodies. Moreover, the text asserts that the principle of transparency is universal and susceptible to being internationalized as a truth that can be embraced by different cultures. Here, two specific concepts are highlighted. Number one, the talisman, quote, relevant to the case and material to the outcome standard, end of quote. And two, quote, good faith in the conduct of the taking of evidence requirement. The third section of the book explores the normative foundation for good faith standard within the rules architecture. A fourth section of this analysis very fleetingly revisits the inherent authority of an arbitral tribunal to impose sanctions in the form of attorney's fees and costs arising from lack of good faith in the conduct of the taking of evidence. By now, it should not be a surprise to you that this issue as well is analyzed through the dialectical prism of party autonomy and arbitrator discretion. In the fifth section, we argue that the principle of transparency is promulgated by the rules in its treatment of document disclosures on grounds for non-production, expert witnesses, and expert reports. And access to original exemplars of translated iterations may prove to be a meaningful point of departure towards moving and arriving at a substantive definition of good faith that is deeply related to transparency and that is subject to normative inferences from the rule's internal workings. The more ambitious aspiration of this section is to contribute to reconfiguring the analytical terms of any conversation concerning the development of transnational rules. for the taking and presentation of evidence. The American influence suggests that this framework should be based upon a standard of equipoise, again, between party autonomy and arbitrator discretion. In turn, such rubric also must emphasize transparency and timeliness as part of a more overarching effort to avoid undue surprises at evidentiary and merits hearing, and to ensure that all parties to an arbitral proceeding shall be equally and best placed to have access to all documents necessary to reach a credible assessment of all risks attendant to the claims, counterclaims, and defenses configuring the arbitral process. The fifth section argues that the principle of transparency as promulgated in the rules, its treatment of document disclosure and grounds for non-production expert witnesses, expert reports, and access to original exemplars of translation may prove to be a game changer in terms of universal acceptance and actually risk assessment. Sixth, and finally, the Prague rules are analyzed against the backdrop of the IBA rules. We already talked about how we thought that the Prague rules were in many ways defective. I want to finish the analysis by letting you know that two chapters are dedicated to 28 USC section 1782. And that is a subject that I have written a lot about, and a statute that I've used a great deal in international commercial arbitrations and treaty-based investor-state ISDS arbitration. That's a statute that, if you're not familiar with it, makes possible the use of US discovery in a proceeding, so long as that discovery is to be used to help a, quote, foreign or international tribunal, close quote. What does that mean? That means that if you have an arbitration in Turkey, or if you have a court proceeding in Turkey, or you have an investigation that is of a criminal nature in Turkey, or you're thinking, reasonably contemplating filing an arbitration in Turkey, and there is evidence in the United States that may pertain to your case, you can file an application under this statute to get a deposition or documents of a non-party or even a party to the pending or prospective case in Turkey. Let me just tell you that that is an extremely, extremely powerful weapon, and one that, or procedural recourse, there's no need to militarize it, but it's a very powerful one, because it makes possible the entire gamut, the entire panoply of US discovery in that proceeding in Turkey, which of course, otherwise you would never get under the law of any nation. And it can, again, move forward the entire settlement process. Why? Because I tell you again, where there is transparency, there is risk assessment. Where there is risk assessment, there is quantification of damages and exposure. And where there's quantification of damages exposure, there's an economic force to settle the case. The book also talks a lot about perjury in arbitration, talks about a whole chapter on arbitral immunity, the immunity of arbitrators in the US and beyond the US, and contrasts those two systems. But each one of those would be the subject matter of an independent lecture. And hopefully I have not put you to sleep enough that you would not invite me in the future to talk about what those two other subjects. So I'd like to take this opportunity to thank you for being so patient and so gracious, and for this wonderful opportunity. I hope this talk has been of some help.
Yes. Thank you, dear Martinez-Fraga, for his valuable and informative speech. Now we move on the question answer part. If any of our participants have a question, they can write in chat section or open the microphone and to take the floor. Yes.
Dear Professor, I have a question, if you mind.
Yes, Emir.
Thank you so much, dear Professor, for this valuable insight. My question is about actually immunities of arbitrators, because as you mentioned that arbitrators have so much discretion on so many important and vital things in the procedure and etc. So I know that in civil law countries, mostly that arbitrators have some responsibilities and of course restrictive immunities. But I believe that in United States it's not the case. So if you can elaborate a little bit more, that I will be more than grateful. Thank you so much.
Thank you. That's an excellent question. You're absolutely correct. In the world outside the United States, maybe Canada, and a couple of common law countries, arbitrators are held to a contractual model of liability. And it's very simple. The arbitrator is a professional who is rendering services. And if you don't render the services according to the expectation, you're liable. You're in the marketplace of consumers, of actors, contractually performing a service. And that's all it is. But in the United States, it's very different. For a number of reasons, some very complicated, but I think dating back to the principle that, quote, the king can do no wrong, close quote, arbitrators are provided with absolute immunity. They have the same immunity that a judge has in a judicial proceeding, with the same reasoning that attaches to a judge. Now, that is wrong, I believe. It's completely wrong, because an arbitrator is not a judge. An arbitration is not a judicial proceeding. An arbitrator is not an extension of the state. An arbitrator is a private actor undertaking responsibilities on an ad hoc basis for pay. An arbitrator is not charged with implementing state policy. An arbitral tribunal, unlike a judicial tribunal, is not a policy tribunal. I'm not saying that all judicial tribunals are policy tribunals, but even those that are not, they are still responsible for considering the policies underlying, for example, applicable statutes and legislation or principles of the common law. The differences between being an extension of the state and being a private actor are extremely meaningful. And an arbitrator, let us not forget, is not charged with the equitable administration of justice. An arbitrator is charged with resolving the practical problem best she or he can under the law. And an arbitrator is thus susceptible to review by a second instance tribunal. So an arbitrator has to be held accountable. I will tell you this right now. I am waiting for in a commercial arbitration case, I'm waiting for an award to come down, and it's been 8 months. 8 months. Now, I will tell you this as well. The only exception to this absolute theory of immunity is where the arbitrator does not perform the job of timely issuing an award. If the arbitrator sits on that responsibility, then she or he can be liable. So that's the big dichotomy. Now, ironically enough, for criminal law purposes, however, in civil law jurisdictions, an arbitrator is treated as a judge and is liable as a judge would be liable. So it's kind of a schizophrenic situation in civil law countries. I think they have the better argument with respect to the civil law treatment, but I think they have the tougher argument from a criminal law perspective in terms of the actions and omissions of an arbitrator. I hope that helps.
Thank you so much.
Another question?
Mr. Martinez-Fraga, I was wondering if we can do an example of cross-examination in here to just let everyone understand better.
Yeah, we can always do a little cross-examination. I will tell you that cross-examination belongs to the world, and it's not really an American phenomenon. In fact, I'm writing a monograph that says that cross-examination has its origins in a work by Plato called the Gorgias. But I'll do some cross-examination right now. You woke up this morning, right?
Yes, correct.
And you checked the news, perhaps?
No, I haven't, to be honest.
No, but you washed your face and your teeth, right?
Yes, correct.
And you got dressed.
Yes.
And you prepared yourself for this lecture, didn't you?
Yes, I did.
And doing so, maybe you read something?
Yes.
Okay, now stop there. This is cross-examination. I have you on a fragmented mode. I have you saying yes or no, and then I'm testifying. So let's assume that we had more facts, and let's assume that there was a breach of contract case. And let's assume that I'm suing, you're suing me for the breach, or you're suing my client for the breach of contract. You're saying that my client did not deliver the goods. My client is saying that that you did not provide for payment. And then we can do all sorts of things. Like, for example, I can start asking you questions about the contract. It said, and you're familiar with this contract, right?
I am.
And the contract has a provision for payment, doesn't it?
Yes, it is.
Payment is an important part of the contract, is it not?
It is an important part, yes, correct.
And you agree with me that without that important part, the contract would have absolutely no economic significance to anyone, right?
Yes, correct.
You can't expect to get something for nothing, right?
Yes.
Now you don't debate that you haven't paid. You see what I'm saying?
Can you please?
So
I couldn't catch. I couldn't catch it. I'm sorry.
I'm saying, no, it doesn't really matter. What I'm trying to show you is that in cross-examination, the examiner is really testifying. The examiner is the person who wants the fact finder, whether it's an arbitral tribunal or a judge, to hear that person, what questions are being asked. The witness is just a pretext for the examination. So you want to fragment the witness completely. Now, if you read Plato's Gorgias, you will see a system of cross-examination based upon a type of question that's asked, a structure to the cross-examination, and a conceptual cross-examination line of questioning based on a conclusion, a very particular conclusion that Plato, or in that case, Socrates, wants to reach. So that's a little example of cross-examination. Usually we can have a session just on cross-examination, but I would have to give you a problem, and we have parts and parties and, you know, and witness statements and all that. But one of the questions that you should ask yourself is, why do we have orality? I'm for it, but why orality in international arbitration? Why oral advocacy in international arbitration? After all, didn't the parties submit their witness statements? Didn't the parties submit ample memorials and briefs? Everything is before the tribunal. And moreover, isn't it a fact that a party can only testify to what's in the witness statement? So why deviate from that? Why do you need oral testimony? Why do you need oral argument?
It's just too fast to think a lie and say it. It is, for me at least, it was just hard to hear and realize what it is and respond. And probably if it was a it was a real arbitration, it was just way too hard for me to think a lie and say it. I guess it is the reason.
I see. When you have orality, you can see things that you can't see with the written word. You can challenge the written word. You can challenge the reasons for a statement. You can observe a person's mannerisms. You can observe how a person speaks. You can judge credibility, truthfulness.
Thank you so much.
Yes.
Thank you.
And may I ask a question, Professor Topaloğlu?
Yes.
Uh,
Yes, please.
Pedro, you know that there are discussions relating to whether the arbitration tribunal can order punitive damages or not. What's your opinion? What do you think about this issue?
I don't think that an arbitral tribunal should be able to award punitive damages. I think that an arbitral tribunal, why? Because punitive damages is something else. Punitive damages has policy considerations that have to do with the equitable administration of justice, with concerns that really are tied to the state and not private proceedings. I think private proceedings should be limited to compensatory damages, save for, as the IBA rules point out, abuses of good faith in the conduct of evidence gathering. I think there you do need some teeth, but that's very practical. Because even though I made it for purposes of stimulating discussion, made it vague that what is good faith? Good faith differs, from family to family, let alone country to country. The truth is, what good faith is and what bad faith is in the evidence gathering. When you're not giving me the information, and the guy say, no, it's in our office in India. Well, you're a Fortune 500 company. You're completely integrated. Of course you can get that information. You know what bad faith is. So I know I'm against punitive damages in arbitration. I think it finds no place. And quite frankly, I don't think I don't think it comports with the nature and structure of arbitration.
What about the investment arbitration? Do you think that even in investment arbitration, the tribunal can order punitive damages?
No, I think that's wrong. I think that in investor state arbitration, ISDS, I think you have the same dynamic all around. That's not a judge, even though it has a public component, because it's treaty based and there are public policy issues. That still no one is acting on behalf of any single country or state. And in fact, by definition, the law that applies is the law of all countries and no single country in particular, namely public international law, conventional or customary. So no, I don't see there's any room for punitive damages in arbitration. I think that's wrong. It's denaturalizing arbitration. It's turning it into something that it is not.
There was a case before the New York.
Wait a minute. I thought you were going to ask one question. Now you're in question number 3. What about all the other people here? I mean, I don't understand what's going on here.
Okay, I will wait.
I'm just kidding. Nuray, come on.
My last question is.
Question number 10.
Yeah, there was a case before New York court, and it was called as Uzan Case. And this case is against the Turkish 5 people. The compensatory damages was around 2 billion, and there was also 2 billion punitive damages. Can you imagine this? And that means that you are destroying the life of the company. Come on, Pedro, how can you order such a kind of huge amount of damages?
Yeah, no, I mean, obviously compensatory, I don't know about the compensatory damages. That's a different analysis. The punitive damages, the idea of punitive damages, that's why I don't think it has any room in arbitration, is to send a message to society, to other potential actors. If you act this way, this will happen to you. It's punitive, but you're punishing and setting an example. There's no room for that in arbitration. Now, the courts have a different mission, if you will. And no, I'm not familiar with the particular case, Nuray, so I'm not in a position to say if that's excessive, but it is extremely common in the United States to have scenarios where the punitive damages are much higher than the compensatory damages. And there are areas of the law, such as defamation, for example, where in defamation per se, damages are assumed. In other words, if the type of defamation is such that that falls into a particular category, damages, of course, are assumed. And those damages, I dare say, generally they're not quantifiable in objective ways. It's left to the discretion. So you're saying, okay, I'm a bad lawyer. And so that goes to a category that is protected, because it's how I earn my livelihood. Okay, so now the jury comes back and says, okay, now you owe me $1 billion. The jury says, $10 in compensation because no one was going to hire him anyway, but $1 billion because what you said is so bad.
Yes, thank you. Then I will ask last question, Mr. Pedro. What is the role of the lex mercatoria in American arbitration?
Well, I mean, I don't do American arbitration. I do international arbitration, but lex mercatoria, of course, has a very prominent place, as you know, in international arbitration, and it's fully accepted.
Okay. Then any question?
From anybody except Nuray, actually, please. Please.
Yes.
Can I ask a question, Professor Topalov? Thank you so much. Dear Professor, you mentioned that the criticism towards the arbitration processes in different countries, like transparency, is not very efficient, maybe, it's not fast. It's not really fast, at least some criticisms towards that way. So I would like to ask that we know that in ISDS, there is a reform process going on, but in terms of commercial arbitration, there are some criticisms against in foundational specialities and etc. So do you expect any structural changes in the near future towards the commercial arbitration?
I do. I think that, first of all, I do think that arbitrators are being invited. I don't want to use the word pressured to act in a more expedited way, to get awards out, to trim the issues, to move the cases along. One of the objectives of a case management conference early on is to set forth the entire architecture of the arbitration with deadlines. I think that there could be greater rigor with that. So yes, I do think that international commercial arbitration is being tested, as is investor-state arbitration. The reality is that with the complexities of cases, arbitration is in some negative way resembling litigation, and I think this is wrong. The idea for arbitration is one of them anyway, is precisely efficiency and effectiveness, and that's completely lost when what you have are these protracted proceedings that last for years. And quite frankly, I think the arbitrators are to be blamed for it and not arbitration. Arbitration is not inherently good or inherently bad. Arbitration is only as effective as the arbitrators make it. Those rules are very general rules. That means that those rules contemplate that these individuals are going to exercise their judgment in ways that are efficient, that are swift, that are intelligent. And look, one of the things that I find in international commercial arbitration to be extremely problematic are the post-hearing memorials. I don't see why there should be post-hearing memorials. I can understand there being memorials pre-hearing so that to make the hearing more efficient, but not post-hearing, except where there are very, very specific questions that were not answered and that the tribunal finds to be material. But what ends up happening is that the tribunal identifies multiple questions that cover the entire case. The parties, after all those years and after all that effort, after a full hearing, end up submitting their position again in writing. Then they raise new issues that were not argued before. And now you have a problem of due process. And there are many things that can be done, is what I'm trying to say, to keep the process, to reform the process, to make it work. The process in and of itself is neither good nor bad.
Thank you.
Well, thank you. Thank you so much.
Thank you. And I will close the conference. We sincerely thank all participants for their interest in our conference. We wish you healthy days. Warmest regards.
Thank you so much. Goodbye.
Bye-bye.